Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello and welcome to Triage. This is Richard Church from K&L Gates Chicago and RTP offices. I co-lead our national healthcare practice, and I'm here today with Mike Hinckle, who leads K&L Gates FDA practice, with another interesting topic: providers subject to FDA inspections and how to prepare for and manage those FDA inspections. So, Mike, thanks for joining us.
Pleasure to be here.
So, Mike, we'll just jump right into the topic. Obviously, folks are familiar with the FDA and its regulatory authority in a lot of contexts, but specific to healthcare providers that may be subject to FDA inspection, can you first just kind of walk us through the context in which those inspections typically come up?
Yeah, sure. I think people oftentimes think of FDA inspections around food facilities or drug manufacturers, device manufacturers, and that is, of course, the bulk of FDA's inspections. But FDA also inspects sites that conduct clinical investigations for drugs or devices, and even sometimes foods or supplements, as well as the institutional review boards that review and approve those studies. So clinical investigators and institutional review boards, or IRBs, are both subject to FDA jurisdiction and therefore subject to inspections. And those can either be sort of a routine inspection, could be part of a pre-approval package. So the FDA is reviewing a new drug application, so they may conduct a routine inspection of the clinical site and how it was performed. Or it could be what FDA calls a directed or for-cause inspection, where they believe there may have been a violation or protocol deviation or something that causes some potential question of the validity of the data. So they may say, hey, we need to go look at that site or look at that IRB and the way they approved a given study or an informed consent form. So it either could be routine or directed. But for an institution, a healthcare provider, most likely would probably be related to a clinical trial that was conducted at their site.
And then as a provider that understands one of those inspections is going to occur, what happens in the actual inspection? What should they actually expect on, during the inspection itself?
Yeah, for drug companies and device companies domestically, anyway, in the United States, FDA often doesn't give any warning. They just show up and say, here I am, I'm here to inspect. But for clinical sites, they often will give a heads up, a phone call. You'd get a call from the district office from the investigator, and that's FDA calls their inspectors and investigators. And they'd say, hey, we're going to come do an inspection, and they may even tell you whether it's routine or directed or for cause, give you some date when they plan on coming. They may even say how long they plan on being there. But don't count on that. FDA has the jurisdiction to just show up at any time if you're a regulated entity and say, here I am, I'm from the Food and Drug Administration, and I'm here to conduct an inspection. And when they show up, they issue what's called a Form 482, which will ask who's in charge. And oftentimes they may issue the 482 to the clinical investigator or the chair of the IRB if it's an IRB inspection. And on that form, we'll have the investigator's name, and on the back, it has FDA's statutory authority to conduct inspections. But they will issue that Form 42. They're required to do so, and they will show you their credentials. It's like an FBI agent. They have these little credentials they show you. Now, I will say, as sort of an aside, if the investigator showing up to do the inspection is also carrying a firearm, that's a sign that they're from the Office of Criminal Investigations. That's not a good thing, generally speaking. And so that would be a sign that they're really looking at a much more serious potential problem. And that may be a good time to contact your legal counsel. But normally that these investigators they're scientific folks, and they show up, they have their credentials. And what you would normally do then would be to take that person, the investigator, and inform them of what your policies are, whether they have to be accompanied in certain areas. You apply the same rules to that FDA investigator as you would to any other visitor. You cannot refuse an inspection. If it's a regulated entity, such as an investigator, an IRB, is subject to inspection by the FDA, they don't need a warrant to do an inspection. They can get one, what's called an administrative warrant, which really just gives them the same authority they have under the statute anyway. They could get that automatically. So it's generally not a good idea to say, hey, go get a warrant, because they can get one, and that just irritates them. The other type of warrant is, of course, an actual search warrant. That requires probable cause of a crime. That's a different type of warrant, has different boundaries to it. But generally speaking, they're able to come in and inspect. But you would then usher them to a conference room or somewhere where you could have them sit down, because these inspections are primarily a review of documents. And they will say, hey, this document, that document. They may give you a heads up ahead of time. And it's a good idea to have somebody available to go retrieve those documents, and also to keep track of each document that you actually show to FDA. And there are some areas where they can't go. Generally speaking, they don't have the authority to look at financial data, personnel records, other than training and qualification records. So good clinical practice training, they have a right to see whether people have been trained. And patient records in the context of studies gets a little tricky, because what happens many times is the clinical study subjects' research records may sort of be intermingled with their patient records. So you have to sometimes be careful to make sure what you're giving FDA is just the research records.
Interesting. Okay. And that maybe dovetails into my next question, which is what are kind of the do's and don'ts as you're managing that investigation day?
Well, one of the key do's really is don't refuse inspection. You always want to make sure, even if you're saying, we're not sure you have the investigator has the authority to ask for that, you always want to make sure you're saying, I'm not refusing inspection. We're questioning whether the agency has the authority for that particular record. And if you get to that point, again, it may be a good idea to contact legal counsel, but don't refuse inspection. That's a key. The other thing is to recognize that the FDA investigator, they're to collect facts. They're kind of like a policeman. And it's important to remember that even though FDA is a, quote, scientific agency, at its heart, it's a law enforcement agency. And the district, the Office of Regulatory Affairs, those investigators going out, their really primary role is to collect data and facts to potentially support an enforcement action. So while they may be very nice, and you should be cooperative with these folks, you have to keep in the back of your mind that they're collecting information that could be used against you or against your investigator, your IRB, and always be mindful of that. It's much like if you folks have ever been advised on how to be deposed. It's the same kind of thing. You want to make sure you give factual information, responses. If you don't know the answer, you say, I don't know the answer. We'll try to find someone who does, but don't guess at an answer if you don't know the answer. And one of the key things I think for people to remember is to not be worried or concerned about the awkward silence. So if the FDA investigator wants to sit there and read through these documents for 15, 20, 30 minutes, and you sit there and watch them read through it, and she sits there and reads for 30 minutes, so be it. You don't need to start getting concerned and start volunteering more information than necessary. Again, those are the same type of things that if you've ever been deposed, same type of thing. Some other key things is sometimes FDA will ask people to sign an affidavit, which may seem pretty harmless, but may just state some facts. And even though the facts may be true, the reason why they're asking for that affidavit is so they don't have to prove those facts should they decide to bring an enforcement action, which could include even a criminal action possibly, or a procedure for disqualification of an investigator where they wouldn't be able to conduct FDA-regulated clinical trials anymore. So we generally advise it's not a good idea to sign those. You're not required to sign those. It's not refusing inspection to say I'm not signing that affidavit. And we would generally advise people that you're not even required to read it or verbally even agree to what's there. You can just say, we're not required to sign these, or you could say, I'm going to refer this to our legal counsel. But it is not a requirement to sign the affidavits. If it's offered to you, it's generally not in your best interest to do so. We sometimes used to deal a lot with photographs, whether FDA could take photographs. Generally speaking, now FDA takes position they can take photographs. We don't see that as much in the context of clinical trial inspections. That's more where we see taking pictures of objectionable situations within a manufacturing plant, for example. I mentioned earlier, warrant. They don't really need a warrant, but they can get one. It's generally not a good idea to demand that they get a warrant because, like I say, they can get one, and when they come back, they generally won't be real happy with having to have had to do that. And at the close of an inspection, so as FDA goes through this inspection, they review documents, and again, keep track of what documents FDA looks at so that you know. Used to be when we would actually give them paper, you can make copies at the same time. Of course, now a lot of it's electronic. You want to make sure that you have a record of everything that the FDA and investigator looked at. And at the close, and they'll tell you we're going to have a closeout meeting, and they'll say, usually they'll want the investigator there, for example, if it's a clinical study that's being investigated, or the chair of the IRB if it's an IRB. And they'll want that person present at the closeout. And what will happen is if FDA has found, they call observations that are potential violations of the statute, the Federal Food, Drug, and Cosmetic Act or regulations, they will issue what's called a Form 483, which is just a list of observations. Again, they're not conclusions that you're in violation. These investigators are again, they're like police officers. They're observing facts. And so they will state these observations on a Form 483. And it will already be typed up before they come to the closeout. And it's important that they recognize that the closeout meeting is not a time to argue with FDA over the observations unless they are just factually inaccurate. The investigator will not change what's on the 483. They may annotate something if you say that's inaccurate, that's not correct, or we've already implemented corrective action there. They may make an annotation, they may not. But you have a period of time, you get 15 working days to respond to the 483. So you'll get your opportunity to respond. You can have a polite discussion with them, but it's not worth arguing with the investigator. They're not going to change the 483 anyway. Now, in some cases, you may not get a 483 at all, but they may still give you some verbal observations. In that case, you should document what those verbal observations are and treat those as things you need to correct before FDA comes back next time. Because when the investigator goes back to their office, they will create what's called an Establishment Inspection Report, or EIR, and that will contain any verbal observations that were made, even if there was no Form 483 observations issued. So there will be a record of even those verbal observations many times. You should get a copy of that EIR after we used to have to ask for them through the Freedom of Information Act. Now they pretty routinely will send a copy of the EIR after the inspection is closed.
And then just to close the loop, then what happens next after the inspection?
Yeah, if you get a Form 483 with observations, you definitely should respond to those. Even if you can't give a substantive response that the observation has been fixed, you should say, here's the corrective action that we're working on. Here's the date that we plan on completing that corrective action, or CAPA. And if it's going to take a while, even propose to say, we're going to send periodic updates to FDA on our progress. In other words, you want FDA to see that you're actively progressing to address the observations. That's if you have multiple observations. Now, if there are multiple observations and serious problems, that could then result in a warning letter is one possible thing, FDA, which is a public letter saying you're in violation and you need to fix it. If it's an investigator issue, it could result in what's called a NIDPO, which is a Notice of Initiation of Disqualification Proceedings, an opportunity to explain NIDPO, which is basically the first shot to a clinical investigator to say, hey, here's your chance to come in and tell us why we should not disqualify you from conducting further FDA-regulated trials. And again, you need to respond to those. Probably be helpful to have outside counsel also help you with responding to either the 483 or the NIDPO if it gets to that. And obviously, you want to do what you can in responding to the 483 to prevent it from escalating to the level of a warning letter or NIDPO, because those are public and can have both damage to reputation as well as regulatory outcomes. And ultimately, the Food and Drug Act is potentially a criminal statute, so there could actually be even criminal violations in some case, or civil money penalties and things, but that's not usually where they go. They usually give people an opportunity to bring themselves into compliance.
Very good. That's all very helpful, Mike. And again, we really appreciate you taking the time today to walk us through. We know this doesn't happen every day, but happens on a regular basis. And we do pretty routinely hear from providers that are planning for an FDA investigation or have gotten notice of that, or on occasion have one happen, again, as you noted, without warning. So this is very helpful. As always, we look forward to our next triage and our next interview, and thank everyone for taking the time to listen in today.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.